I thought today would be a good day to talk. Oh, I am. Let me. There you go. Okay. The world is exhausting me. Yeah, I think the world is exhausting all of us. I think it's been a few it's been a few days that felt like weeks, right? Okay, so I wanted to start the conversation today by tired, by talking about this thing that we didn't talk last week because we didn't have time on whether recognizing Palestine violates the Montevideo Convention. I know someone mentioned that you guys were interested on this, um, and I feel like yeah, I've touched upon Palestinian statehood before, but not through the lens of the Montevideo Convention because I'm not really I'm not really a fan of reading the Montevideo Convention in the way that the West reads it. So okay, so let's do that. Let's start today with our conversation on statehood of Palestine, recognizing Palestine, and whether or not that violates the Montevideo Convention, and if in so doing, then it therefore violates international law and it's illegal to do it. Right? This in the context of the United Kingdom, France, Canada, and a bunch of other states declaring that they might recognize Palestine in September when the GA, the United Nations General Assembly, meets, right? And so there was a letter signed by a bunch of British lawyers, politicians, lords, um, arguing that it would violate international. So let's read the letter first and see what the claim is. Okay. SV says, is recognition just more BS? Is it going to legitimize these crappy policies the way also legitimize the settlements? So you can look into my video on Palestinian statehood. I actually addressed that and why I am not convinced that the two-state solution would solve anything. So you can check that video out. It's on my YouTube page. I cover that there. I don't think we need to go into that territory to address this recognition, but if we have time, we can talk about it as well. Otherwise, just yeah, you can check the video. Um, Samson says, "What is materially different from Israel being recognized in 1948 and Palestine today?" Nothing really. Like materially different. The situation continues to be that Israel seceded from the mandate of Palestine and refused to sign a treaty with the host state from which it seceded, which is Palestine, and therefore it's in a situation of limbo. The only secession case in the history of international law where the secessionist party has been recognized by third states, but not by the host state. So picture this in the sense that let's say that Quebec decides to secede unilaterally from Canada. Most likely, no one would recognize Quebec. No one would want to, get into a fight with Canada by recognizing a breakaway province. So most likely, Quebec would need to secede through legal means with the consent of Canada, which is why secessionist parties don't usually secede unless they do it through war. Um, say the Confederates in the United States, right? Um, and so in Israel Palestine, we have this very weird situation where the host state, Palestine, uh, has not agreed to recognize the secession of Israel, and yet everyone else in the world, like 164 states in the world, have recognized Israel as a state that seceded from the mandate of Palestine. So it is a weird situation for sure, but materially different from Israel being recognized in 48. It's the other way around, right? It should have been easier for states to recognize Palestine, not Israel. The reason why they recognized Israel and not Palestine is mostly because of Orientalist reasons. Um, but yeah, okay. So let's start by reading that letter, shall we? What's this letter? Here it is. I don't know if you guys can see this. Let me make it bigger. I don't know how to zoom to this. Hold on. That's better, right? I think you can read that. So this is a letter addressed to the Attorney General of the United Kingdom, Lord Hermer. This is in relation to the announcement that the Prime Minister intends to recognize Palestine on certain conditions. We call on you to advise him that this would be contrary to international law. So the argument is that this violates international law. Okay. As you must know, Palestine does not meet the international law criteria for recognition of a state, namely defined territory, a permanent population, an effective government, and the capacity to enter into relations with other states. This is set out in the Montevideo Convention, has become part of customary law, and it would be unwise to depart from it at a time when international law is seen as fragile or indeed at any time. I have a lot to say about that paragraph, but let me just read the letter first, and then we can talk about why that paragraph infuriates me. Okay. It is clear that there is no certainty over the borders of Palestine. Could the government continue to recognize millions of Palestinians in the West Bank and Gaza as refugees and claiming the right of return to Israel, even though the effect of UK recognition would be that they are on their own territory? There is no functioning single government, Fatah and Hamas being enemies. The former has failed to hold elections for decades, and the latter is a terrorist organization, neither of which could enter into relations with other states. You are on record as saying that commitment to international law goes absolutely to the heart of this government and its approach to foreign policy. You have said that a selective pick and mix approach to international law will lead to its disintegration, and that the criteria set out in international law should not be manipulated for reasons of political expedience. Accordingly, we expect you to demonstrate this commitment by explaining to the public and to the government that recognition of Palestine will be contrary, again, that claim, contrary to the principles governing recognition of states in international law. We look forward to your response. And then the names of all the people that signed this, lots and lots of earls, lords, and baronesses and barons. So let's frame this letter in the context of the international law of recognition of states. Right, so the law on statehood is one of those things that are probably the most misconceived aspects of international law. I think comparable only to embassies. You know that claim, typical Simpsons claim, where like Bart goes to, I think he goes to Australia, and he goes into the United States Embassy in Australia, and then he jumps into Australia and says, I'm in Australia, then jumps back at the embassy and says, I'm in America, I'm in Australia, I'm in America, I'm in Australia, I'm in America. That's not how embassies work. Embassies are not the foreign territory of a state in another state. They're not sovereign territory. They are the territory of the host state. It's just subject to immunity, right? That is likely the most common misconception the public has about international law. That embassies are little like enclaves of territory in other states. The second most common misconception, I think, is that statehood is a checkpoint. It's a set of checkpoints. Not checkpoints, checkboxes, sorry. That statehood is a set of checkboxes. And that if you go to the Montevideo Convention and you go like, checkbox number 1, do you have a territory? Checkbox number 2, do you have a government? Number 3, do you have capacity to engage with other states? And number 4, do you have a population? Then that's it, you're a state. That is really not how international law defines a state. The reason why this is what is presented as the definition of a state is because it is very easy to frame it in these terms when one reads the Montevideo Convention. It's easy to go like, oh, which treaty defines a state of all the treaties that we have? Oh, there's one that was signed in 1933 in Montevideo that has a very simple definition. Let's use that. But it leaves out a bunch of stuff that happened from 1933 onwards that matter for recognition of states that didn't matter in 1933. Namely, most importantly, decolonization and self-determination. Right, that is a key factor here, and the right that the International Court of Justice has recognized for Palestinians. Right, Palestinians have a right to self-determination, external self-determination. They have a right to form a state as a nation, and so the idea that you can just like check box and say, oh no, you're not a state, forgets that, leaves that out, leaves decolonization, leaves self-determination out. And I just think that's a terrible way of approaching statehood, because like if you want to understand states, even at the time, even in the 1930s and 1920s, the definition of state that's incorporated into the Montevideo Convention isn't really very representative. In 1929, Italy signed the Lateran Treaty with the Holy See to solve the issue of the papal states, and recognize the existence of a state called Vatican City State. This is 1929, so 4 years before the Montevideo Convention. What was Vatican City State? Vatican City is a portion of Rome, very, 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 very small, um, that has essentially no capacity to exist as a state without Italy, without Italy's support, without being there, like without like being able to go into Italy and buy stuff in shops or like do stuff like have electricity, have telephones. It's incapable. If Italy did not exist, the Vatican City would not be able to operate. Right? It's better understood as a neighborhood than a state, and yet it is a state because Italy said so. Right? So in this 1929 treaty. And so it is unquestionably so a state. Okay, no one questions that Vatican City is a state. And yet it has this like um, very powerful government, the Holy See, that has control over a territory, a neighborhood of Rome, but sure, a territory. And it has no permanent population. Who lives in the Vatican? Swiss papal guards, the Swiss guard of the Pope, bishops, the Pope, and a few bureaucrats for the church. What is their status there? Well, they are appointed by the Pope, so they come by appointment, and then they leave when the Pope tells them to, when their mandate terminates. No one is born in Vatican City State. Think about it. I mean, these are people that have all vowed celibacy. No one is born in Vatican City State. How can that be a population? Even more so, a permanent population when these people are come in for a job and then leave when they get another job. So Vatican City does not meet the requirements of the Montevideo Convention, and yet it is a state, right? Similarly, the Holy See, the government of Vatican City, it's two things. One is Vatican City, the other one is the Holy See. The Holy See is the representation of the Catholic Church on earth, right? Is also a subject of international law. It's a non-state sovereign entity. There are only two in the world, the Holy See and the Sovereign and Military Order of Malta, which is the last of the military orders of the medieval times that survive to this day. Neither of them have a territory. By definition, they're a non-territorial entity. And yet they are sovereign. So yeah, they're not states, but they have sovereignty. So just on these three examples, this very checkbox definition of state doesn't add up. It doesn't add up for Vatican City. And then also it doesn't add up for some territories that, if it's a checkbox, then they should be recognized as states, right? How many states recognize Taiwan? Taiwan has all the elements: a permanent population, a government, capacity to engage with other states, and a permanent population. But it's recognized, I think, by like 4 or 5 states in the world. If this is how you want to understand statehood, is that a violation of international law? Is not recognizing Taiwan a violation of international law? Of course not. Because there's something else to the recognition of states. There's something else to statehood that matters here, that is politics. States are political entities. They have emerged and submerged through history, through a bunch of exceptions over the centuries. And to pretend that you can just like siphon them into a 4-item definition in a treaty is sort of bonkers. It's not, that's not how it works, right? But again, you go to the Montevideo Convention, the Convention on Rights and Duties of States of 1933, and there's a very nifty, very simple definition here. Where is it here? A state, the state as a person of international law should possess, and there is an aspect of interpretation here, because in English it says the state should possess, but in Spanish, just to be sure, it says el Estado como persona de derecho internacional debe, must, right? There's a different, a state as a subject of international law must have the following requirements. So I don't know why it says should, but in Spanish it's must. And should possess the following qualifications: a permanent population, a defined territory, government, and the capacity to enter into relations with other states. This is a good set of checkboxes. These are things you should check to see if something is a state, but it doesn't exhaust the exercise. Why? Because This is Article 1 of the Montevideo Convention. What was the purpose of the Montevideo Convention? Was it to define what a state is? No. The Montevideo Convention does not set out to define what a state is. If you keep on reading, yes, it talks about what a state is, like what a federal state is. But you can see in Article 3 already, the political existence of the state is independent of recognition by other states. Even before recognition, the state has the right to defend its integrity and independence, to provide for its conservation and prosperity, and consequently to organize itself as it sees fit, to legislate upon its interests, administer its services, and to define the jurisdiction and competence of its courts. So this is what do you call it? A declarative concept of recognition. Recognition doesn't create the state. Recognition just declares that a state already existed, and that state has already political existence even before another state recognizes it. This is very much meant from the perspective of a Latin American community. This is the Montevideo Convention, signed by many Latin American states and the United States. In the sense of, like, when we declared independence from Spain, we didn't need permission, we didn't need recognition from Spain to be states. That's where this article is going. And so you can see that sort of angle, that very, like, we have rights as sovereign states through the convention. States are juridically equal, enjoy the same rights, and have equal capacity in their exercise. The rights of each of one do not the rights of each one do not depend on the power which it possesses to assure its existence, but upon the simple fact of its existence as a person under international law. The fundamental rights of states are not susceptible to being affected in any manner whatsoever. The recognition of a state merely signifies that the state which recognizes it accepts the personality of the other, with all the rights and duties determined by international law. You can see it's not trying to define states so much as it is trying to say we are all equal under the law here. We, the Latin American states that have spent the past 100 years being invaded and attacked by the United States and Europe, are stating we have the same rights as Europeans and Americans in the course of our international relations. That's the point of the Montevideo Convention. So it says no state has the right to intervene in the internal or external affairs of another. And this is pre-UN Charter, mind you. So this is a very advanced treaty for its time, ahead of its time. The jurisdiction of states within the limit of its national territory applies to all of its inhabitants. So diplomatic protection, where a state comes in and says, that debt you have with that corporation, now it's my debt. I'm the United States, and I'm going to blockade your ports until you pay your debt. That can't happen. Article 10, the primary interest of states is the conservation of peace. So don't go invading us, United States. That's the point of the Montevideo Convention. And then you get to Article 11, which is the most important and my favorite article of this entire convention. That says, the contracting states definitely establish as the rule of their conduct the precise obligation not to recognize territorial acquisitions or special advantages which have been obtained by force, whether this consists in the employment of arms, in threatening diplomatic representations, or in any other effective coercive measure. The territory of a state is inviolable and may not be the object of military occupation nor of other measures of force imposed by another state, directly or indirectly, or for any motive whatever, even temporarily. No one cites this article, but it bans occupation. No one cites it because this article was not meant to define this treaty was not meant to define what a state is. What this treaty was hoping to achieve was to keep the United States from invading Latin America as it had done so throughout the second half of the 19th and first half of the 20th century. That was the point. So it defined the state in the sense of saying, like, I'm going to set up all my arguments about the equality of states by having a working definition of state that sort of applies to Latin America. Like, we don't really have in Latin America many secessionist movements, especially in 1933. So there was no need to go into a lot of details about the politics of recognition and international law because, like, all the states in the area were already very solidly established. So, but this article became the rage when it's, one convention defined what the state is. So everyone started using it and quoting it and quoting it and quoting it. And everyone started just quoting this Article 1, Article 1, Article 1, Article 1, never quoting any other article. And all of a sudden people started saying, this is the definition of state. It's recognized so under customary international law because everyone cites it. Everyone agrees that this is the definition of a state, and that's it. That's the only part of this convention, this very important foundational, definitional convention in the history of Latin America. We're just going to reduce it to Article 1. and we're going to say that the point of this convention is to define the state. I've seen that before. So, oh, the Montevideo Convention, comma, the convention that defines a state, it drives me crazy. This convention does not set out to define the state. It even does a poor job by the standards of the 1930s because Vatican City had just been created without a permanent population. Right? And now by the standards of today, it doesn't incorporate the right of peoples to self-determination, which you can, I mean, we can discuss when it was created, but it was accepted by the broader international community, particularly the global north, at around the 1940s, 1950s maybe. Right? So it really drives me mad that this convention is reduced to this Article 1 and then ignores every single other future development of international law, as if international law has to be trapped in time because a few Latin American states and the United States signed this convention. It just feels wrong to me, right? That is not how I would interpret the creation of states under international law. Hold on, let me catch up with the chat. So Odar says, of course, the U.S. would go on to try and usurp any and all independence of Latin America. Oh yeah, absolutely. Like the Monroe Doctrine was essentially the United States invading a bunch of Caribbean states, one after the other. Dino Expertin says, the West demanding that the Palestinian state must be demilitarized and that the armed groups like Hamas can have no political role is basically just calling for a Bantustan under Israeli Western supervision. I mean, again, I recommend that you check out my video on Palestinian statehood where I discuss why the two-state solution doesn't work. I address that point specifically. So yeah, go check it out. Oh, hey, Magic, I just saw you were here. So, okay. So I don't think this is how you establish a state under international law today anymore. I would argue it never was, because this article never meant to establish a rule for the entire world for all time. It was just a practical way of defining state in the context of Latin America, in a convention whose object and purpose was not defining a state, but protecting states from the attacks of the United States at a time where the United States had finally signaled, you know what, I'm going to be a good neighbor. I'm going to sign a treaty with you guys about how we're all going to sing Kumbaya, and I'm not going to invade you, at least until the Cold War starts 15 years later, and then I'm going to invade you again. That's it. This is this treaty. This is the Montevideo Convention. It's the treaty through which the Monroe Doctrine of the 1920s, 1910s, and 1890s came to an end. Latin America beat the United States into, well, not beat, like forced the United States into signing this treaty because otherwise it would not have any kind of pull over Latin America. Essentially, the Latin Americans said, look, do you want us to continue to vote with you and continue to like be on your side? Then it's about time that you sign this. That's it. That's the Montevideo Convention. So just to give you an idea then, even if this defined what a state is, even if this was the general rule of what a state is, it wouldn't be contrary to international law to recognize a state that doesn't fulfill these requirements, because no rule of international law is being violated. In that the article does not say no state will recognize another state that does not, another entity that does not comply with these items. It just doesn't say that. So recognition of another state that doesn't comply with these requirements would not violate international law. And so after the signing of this letter, this very good article by Marko Milanovic, who is an excellent international lawyer. Let me put it this way: if he is a very positivist guy. He is a very like black letter interpretation of the law. So this is not an article written by a post-colonial woke scholar or like someone like me. This is very like, if Marco says it, you can sort of like say this is the mainstream understanding of what black letter law says right now. And it was very interesting because he wrote a very short article essentially saying, what are you talking about? No recognizing Palestine would not be contrary to international law, as the title here suggests. So I wanted to read it with you. It's very short, just so you can see the arguments that Marco makes that are in line with what I've been telling you. But I guess from the perspective of a much more black letter interpretation of the law, right? So he says, a group of British peers, among them several distinguished lawyers, yesterday sent a letter to the Attorney General, Lord Hermer, asking him to advise the UK government that its announced forthcoming recognition of the State of Palestine would be contrary to international law. I have to say that the letter, whatever its political purpose or effects might be, is underwhelming. Like, I went online one day and saw, 20 international law scholars all saying, this is crazy. What do you mean that it would be illegal to recognize Palestine? So the letter is underwhelming, to put it mildly. The authors argue that Palestine fails to fulfill the Montevideo effectiveness criteria for statehood, a topic discussed ad nauseum in the literature, like you should have done your homework, to say that they do this without any nuance. To say that they do this without any nuance would be an understatement. Example, in the first paragraph, they just assert that Hermer must know that Palestine does not meet the criteria for recognition, as if this was somehow an uncontroversial position. And again, it is not. Palestine, as I say in my video on the statehood of Palestine, Palestine is actually very much compliant with the requirements of statehood at this point. Marco continues and says, it can reasonably be argued that Palestine does not meet the Montevideo criteria and that it does not currently exist as a state. Me and Marco disagree on this, but it can also be reasonably argued otherwise. This is not an obvious issue. This is why, for example, both the ICC and ICJ have so far avoided pronouncing on Palestinian statehood under general international law one way or the other. Yet it is crystal clear that the Palestinian people have a right to establish their own state by virtue of their right to self-determination, which is what I was talking about, which has twice been authoritatively reaffirmed by the ICJ. Curiously, this is a right that the letter authors do not even mention. It is also clear that the international community, especially states acting collectively, can compensate for any defects in effectiveness. This is how, for example, entities such as the Holy See or the Sovereign Order of Malta have been endowed with legal personality, or how the statehood of microstates is uncontested, or how many states emerged into being through decolonization despite having very weak governments, weak territorial control, or contested borders. Exactly. Not only that, I would say, right now, we are discussing at the International Law Commission level, we are discussing what will happen to those like small island developing nations that exist in the Pacific and that are sinking into the Pacific Ocean because of rising sea levels. We are discussing that because there is a very solid argument to make that once you are a state, even if your territory fully disappears, your population, your government, would continue to exist without that territory, and that your legal personality would continue despite not having a territory. Because otherwise it would be sort of genocidal, right? It would be like, oh, your territory sunk, now you are all stateless. That can't be. The fact that we're discussing that means that the 4 criteria of Montevideo are, to quote Captain Jack Sparrow, more like guidelines than actual rules. So Marco continues here and says, with the passage of time and through the gradual increase in recognition, the statehood of Palestine has become increasingly clear. When James Crawford, who is like the main scholar of statehood up until the early 2000s, wrote 35 years ago in the European Journal of International Law that it was too soon to say that Palestine was already a state. This is likely not what he would write today if he was still with us. What really boggles the mind when it comes to the letter is not that it presents the question of statehood of Palestine as one on which the answer is obviously in negative. Rather, it is the bold assertion that any recognition of Palestine by the UK would be contrary, keyword contrary, to international law, rather than simply being ineffective. Which would be a more reasonable argument to make. The argument would be like, you're going to recognize the state and nothing's going to change. Let me get this straight. So the 3/4 of all states in the world that have so far recognized Palestine as a state have okay, let me get this straight. So the 3/4 of all states in the world that have so far recognized Palestine as a state have somehow done this in violation of international law. And if France and UK and Canada did the same, they too would violate international law. This is plainly incorrect. Rosova says, Jack Sparrow doesn't have any peer-reviewed literature. I would expect better from you, Alonso. Well, but his brother is keeper of the code, so that counts. Dino Expen says government in exile. Yes, but then a government in exile isn't a government without a state. It's just that the state is occupied, but it still exists. But it is sort of like it can be a state with two governments. So again, the Montevideo Convention criteria are guidelines. Um, I'm almost done. Marco says, recognition is precisely a device through which contested claims to statehood can gradually be resolved. Yes, there are some cases in which the act of recognition can violate international law. When Russia recognized the statehood of the Donetsk and Luhansk People's Republic in February 2022, that act of recognition alone, regardless of the invasion that followed it, was a violation of Ukraine's sovereignty and an intervention in its internal affairs. Again, check the Montevideo Convention article beyond Article 1. Indeed, the UK Prime Minister at the time acknowledged this illegality, saying that the recognition was plainly in breach of international law. Yes, because it violated an existing rule that says Ukraine has territorial integrity over all of its territory, and if you are recognizing another entity arising from it, that would violate international law. If the UK recognizes tomorrow the independent Republic of the Negev in Israeli territory, then yes, that would probably violate Israel's territorial integrity as well. But that's not what's happening here. This is a flagrant violation of the sovereignty and integrity of Ukraine. This was not simply because recognition was extended to entities that legally did not qualify as states, but because these entities existed on the territory of another state, Ukraine, whose rights were directly affected. This is simply not the case with Palestine and Israel. Recognizing Palestine would in no way violate any rights of Israel. On the contrary, it is precisely Israel which, as established by the ICJ through its continued illegal occupation of Palestinian territories, is preventing Palestine from fulfilling the Montevideo effectiveness criteria. It is Israel whose government and parliament have repeatedly rejected any attempts to establish a Palestinian state, despite the Palestinian people's right to self-determination. It is Israel which is manifestly pursuing annexationist policies. In such circumstances, I simply fail to see how any British recognition of Palestine would be contrary to international law. It might be a good idea or not. It might actually achieve something or not. But any such recognition would be perfectly lawful, and I'm sure the letter authors must know that. So I found this very interesting because then when reading this, one of the letter authors actually responded to Marco with a reply article. But it was a very particular reply article. This is by Lord Guglielmo Verdirame, who is a professor at King's College, and also a lord. It's a very particular article because it's longer, so I don't know if I'm going to read it all. But just to make the argument clear, it sort of like abandons this contrary to international law claim and moves the goalposts away from contrary to international law into probably a bad idea, which was sort of Marco's original point. And so we end up with this situation, this weird situation where like the author, I guess the most respected lawyer in the letter, sort of doesn't defend the letter from the attack it's received, meaning that Marco is right when saying that the letter was very underwhelming. Again, most of my friends that are international legal scholars, and myself included, think that the letter was weird. That it was badly phrased. It was bad international legal analysis. And when Professor Verdirame doesn't defend that claim, it makes it look like, yeah, something happened with that letter. Like something happened there. So is this. I'm going to read this faster because it's too long, okay? It's too long of an article. It says, in disagreeing with the letter on the possible British recognition of Palestine, which I signed with other parliamentarians, Marco contends that the argument that Palestine satisfies the Montevideo criteria for statehood and the arguments that it does not are equally reasonable, and that any British recognition of Palestine would be perfectly lawful. The Badminton Commission captured the Montevideo criteria and the rules on recognition of statehood as follows. This is the commission that decided the partition of Yugoslavia. A state in international law is a community which consists of a territory and population subject to an organized political authority characterized by sovereignty. The existence or disappearance of states is a question of fact, and recognition merely declares the existence of this fact. Marco suggests that Judge Crawford would have taken a different view today from 1990, when he wrote in Egil that it was too soon to say that Palestine was a state. At that point, more than 100 states had already recognized Palestine. By the time of the second edition of the Creation of States in 2006, Judge Crawford's view that Palestine lacked the attributes of statehood had not changed. Dr. Grant, the person who was co-writing, most closely involved in that second edition, is still of that view, as he explains in a forthcoming book. What Judge Crawford did contemplate in 2006 was the possibility that international law might one day permit recognition notwithstanding the facts. This is how he explained it. Thus far, international law has distinguished between the right to self-determination and the actual achievement of statehood, and for good reason. It can be argued that the position is different when the requirement in favor of statehood of a given territory is imposed by general international law, and in particular by a peremptory norm such as the right to self-determination. Um, but in the situation where state structures have not yet been created in fact, and where serious issues remain to be resolved about the constitution and boundaries of the putative state, its obligations towards minorities on its territory, and the question of commitment to respect to rights of neighboring states, statehood should not be regarded as existing already, as it were, by operation of law. See, I don't get this, because then this throws the argument for self-determination in decolonization out the window. During decolonization, many governments were not really under control of their territory. Borders were not all well defined, even with the application of the Otti Possidetis principle. And so, like, I mean, right now, Colombia and Peru are fighting over a little island in the Amazon that they don't know who owns it, and they have a limits treaty. So, borders being undefined is sort of like standard. Especially at the time of decolonization. And one of the main victories of the decolonization era was the securing of an automatic right to self-determination. Like, you do not need a mandate system anymore. You do not need to wait until you are quote unquote ready to be a state. To be a state. If you were a colony, you were now going to be a state automatically, ipso facto. And we were going to recognize that regardless of the situation on the ground, regardless of whether you controlled your entire territory or not. Like, in fact, the United States recognized Israel like the day after they declared their independence, when Israel wasn't in control of all its borders. So I don't understand this argument. It feels to me more like an argument designed to say there is a reasonable reason why I'm not saying that Palestine is a state, more than an actual statement of international law, because like so many situations exist in the history of international law that would contradict the statement that, oh, you need to wait till the facts to be right. Nonetheless, this may not be the whole story, Crawford continues. There may come a point where international law may be justified in regarding as done that which ought to have been done, if the reason has not been done is the serious default of one party, and if the consequence of its not being done is serious prejudice to another. So basically, this is what Marco is saying. This is this paragraph here. It is precisely Israel which, as established by the ICJ through its continued illegal occupation, is preventing Palestine from fulfilling the Montevideo criteria. There may come a point where international law may be justified in regarding as done that which ought to have been done, if the reason has not been done is the serious default of one party, and if the consequence of it not being done is serious prejudice to another. Those two things are the same. Crawford is saying what Milanovic is saying, and yet Verdirame is arguing that in reply to, in contradiction to Milanovic. It's a weird, I guess it's a weird flex here. This is not doing what he thinks is doing, I think. Circumstances can be imagined where the international community would be entitled to treat a new state as existing on a given territory, notwithstanding the facts. When dealing with the effect of a unilateral declaration of statehood by the PLO, he wrote, "The essential point is that a process of negotiation towards identified and acceptable ends is still, however precariously, in place. That being so, it misrepresents the reality of the situation to claim that one party already has that for which it is striving. It may also be counterproductive." Again, this is the idea that Palestinian statehood has to be conditioned to a negotiation with Israel. But I mean, I thought we really liked the Montevideo Convention, right? Which says that recognition. Where is recognition here? It says subject somewhere. Where is it? Recognition is unconditional. So you cannot say, I will recognize you, Palestine, once you sign peace with Israel. That's conditional. So if you really like the Montevideo Convention, then that doesn't work. And I know it's conventional wisdom, and it was conventional wisdom in 2007 when James Crawford wrote those lines. but it isn't anymore, right? That's, I mean, come on, really? We're saying that Palestinian statehood has to be conditioned to a peace process? What peace process? So I'm really unconvinced by this like reference to Crawford, which arguably seems to be agreeing with Marco more than with Lord Verdirame. Um, So he says, like, yeah, Crawford might have gotten there, but he didn't before he passed. But 3 points would have been critical to this analysis. He continues. First, it would have to be shown that at some point after 2006, the legal paradigm that served us well for a long time, through the creation of new states following decolonization and the collapse of the Soviet Union and Yugoslavia, was replaced by a new one. It wasn't replaced by a new one. It was always flawed. It was relied on by specific actors in specific circumstances when it worked. But it was not used, for example, during decolonization. No one said, oh, you don't have full control over your territory, you cannot be a state. I'm so sorry, you cannot declare independence. You are not a state. Like Algeria, I'm sorry, your revolution needs to be put to a stop because like you cannot become independent because you don't control the entirety of Algeria just yet. So you're not really a state. That doesn't work. So I don't think that it would have been replaced by a new one. I just think it doesn't work the way Lord Verderame thinks it works. There would have to be some clarity on new criteria. For example, should a state that ought to exist but does not exist be treated as existing in all cases of protracted frustration of self-determination, or only in some, and if so, when? But this idea of a state that ought to exist but does not exist sort of grants constitutive qualities to recognition. The state cannot exist until someone says you have the right requirements. And again, if you really like the Montevideo Convention, you can see that recognition. Let me find it. The political existence of a state is independent of recognition by other states. So, what do you mean the state that ought not exist but doesn't yet? Like, what do you say? What do you mean by that? What do you mean by this phrase? Should a state that ought to exist but does not exist, according to whom? Is it recognition that creates the state? Because if so, you are going against the rules of the Montevideo Convention. Second, whether state practice now supports such a change is not a simple question of numbers. The numerous instances of recognition of Palestine have been made on different bases and with various caveats. Crucially, it would be necessary to establish that these statements evidence support for new legal principles of recognition and statehood. I mean, no. Many of these states just say that Palestine fulfills all 4 requirements of the Montevideo Convention, that nothing else is needed. I don't see the need for new principles here because the 4 principles of the Montevideo Convention have been applied by many of the states that recognize Palestine, and I don't think no one has said, even though Palestine doesn't fulfill the requirements, I will still recognize them. I don't think that anyone has done that. Third, while often dismissed as a dead letter, the series of Israeli-Palestinian agreements, which began with the Declaration of Principles of Interim Self-Government Arrangements, so the Oslo Accords, were never denounced by either side and are still in force. In its 2024 advisory opinion, the ICJ proceeded on this basis. An effect of these agreements is that the state of Palestine is not only factually untenable to exercise the whole range of governmental powers within the territory concerned, but also legally precluded from doing so. Since 2006, the situation has got worse as the PA lost control over Gaza. Again, it's Israel that is making this impossible through the Oslo Accords. So why is that on Palestine? And the separation of Gaza, there are many instances of states right now that don't have control over a specific part of their territory because an armed group has taken control of it. Right now in Peru, my country, in Peru, there's an area called the Valle de los Ríos N. Apurimac Imantaro, VRAEM. VRAEM. It's a region, it's an acronym. And it is mostly in control of Shining Path remnants, armed groups. The government has a really hard time keeping control over that area. That doesn't mean that Peru is not a state. And then Gimmicky Francie says, let's not forget that Oslo was interim. Yeah, but not only that, it is an agreement between two parties. It is not a use Gogan's right like self-determination, right? It is difficult to see, Verdirami continues, how there could be any serious disagreement with the proposition that if Palestine was not a state in the Montevideo Bad sense in 1990 or 2006, it cannot be a state in that same sense in 2025. The only way in which Palestine can be said to be a state today is on the basis of a different sense of statehood and recognition, i.e., the principles would have had to change along the lines sketched by Judge Crawford 19 years ago. Or Judge Crawford was way too much into the four criteria, and those four criteria were actually not. Okay, two things can happen, right? Either those four criteria, again, more than guidelines, more guidelines than rules, or two, Palestine fulfills the four requirements. It has a government, the government of the state of Palestine in Ramallah. It has a defined territory, defined enough so that Israel, that shares all 40% of Israel's borders are with Palestine, claims defined borders. So if Israel can have defined borders and border them with Palestine, why can't Palestine? Right? It has a permanent population, the Palestinian people, and it has the capacity to engage with other states. 148 states that have decided to engage with Palestine. So no, there's no need for any new rules. The four criteria of the Montevideo Convention, let's say the gold standard way of saying that something is a state, are met with Palestine. Does that mean that any entity that doesn't fulfill those four requirements cannot be a state? No, it really doesn't. The Vatican City exists. The Sovereign Order of Malta exists. Decolonization happened. Right? But definitely, if you fulfill those four requirements, you definitely are a state. And I think Palestine fulfills them. And I think most of the states that recognize Palestine say that Palestine fulfills those requirements. So I really don't see this like, oh, we need a new sense of what a state is. I don't see that. I don't share that concern by Lord Verderame. Interestingly, nothing in the British government's statement suggests that the legal justification for recognition hinges on the kinds of epiphany that some may be experiencing, suddenly realizing that applying the same test, similar or worse facts today can yield the opposite legal conclusion from before. But the fact that those defending the government, including Marco, Lord Sumption, and Baroness Kennedy of the Shaw, Baroness Kennedy of the Shaws, in a letter to the Times, sorry, weird. I thought it was like Shaw, the KC Shaw, the lawyer, are making their argument on the basis of the Montevideo Paddington on the basis of the Montevideo Paddington paradigm confirms that. If the legal test has changed, few seem to have noticed. I mean, I don't think anyone is writing books about the definition of a state just on Montevideo. I don't agree. I don't agree. Let me skip this a little bit. If things have changed, we should be told how and why, and parliamentarians have every right to demand an explanation. They don't need to change. I think Palestine fulfills those four requirements. But things have changed. Self-determination happened. Decolonization happened. All of these things happened, and they did alter what we mean by state when we declare a state, when we recognize a state. That did happen. Things have changed, but they don't need to change for Palestine to be a state. Does that make sense? So, for example, he says, if the policy is that the protracted frustration of self-determination justifies recognition of statehood, notwithstanding the facts, then why is Britain refusing to recognize Western Sahara as a state? Britain has recently moved in the exact opposite direction and now supports Morocco's autonomy plan, which negates the Sahrawi statehood. This is a fantastic argument. Yes, let's recognize Sahrawi statehood. Let's recognize Western Sahara. It makes perfect sense. I fundamentally agree with Lord Verdirame that Britain should recognize Western Sahara. Why is this a counter-argument? Why is Britain is acting against the self-determination of the Sahrawi people an argument to say it also should go against the self-determination of the Palestinian people? Gimmick Francie, I don't think that Western Sahara is a different kind of argument than Palestine. It's also a situation of long-term occupation and self-determination. But let's not open that kind of worms right now. Let me continue. This is where I think there's a fair point in Lord Verderami's article. He says the British statement instead imposes conditions on Israel. Britain will recognize the state of Palestine in September unless Israel takes certain steps, including agreeing to a ceasefire. This third-party conditionality means that the recognition of Palestine is framed as a punishment against Israel in the affirmative, and no less absurdly, the continuing non-recognition of Palestine is floated as a potential reward for Israel. So I wouldn't frame it in these terms, but I do agree with the sentiment that recognition should not be conditional. It's in the Montevideo Convention, after all. Recognition should not be conditional, particularly in this case, because if there's one thing that needs to be clear, and it's a common talking point by Zionists, is that recognizing Palestine, they argue, recognizing Palestine is a reward for Hamas, and that it means that if you commit terrorism, you are rewarded with a state, which is an incredibly hypocritical statement considering that Israel got its statehood after committing terrorism. But it is important to state that that is not true. That's not how it works. The entity that would be recognized as the government of Palestine and as the Palestinian state is not Hamas, is the state of Palestine. So it cannot be a reward for Hamas to recognize their rivals as government. Like I think Verdirame himself calls Fatah and doesn't he? He calls does he oh, is it? It's the letter, right? It's the letter. Where is it? Yeah, there's no functioning single government, Fatah and Hamas being enemies. So how can rewarding Fatah, or the administration in Ramallah, be a reward for Hamas, the enemy? So the letter itself sort of takes care of that. Where is it? Okay, here it is. So it's very important to state that recognition of the Palestinian state does not reward Hamas. It rewards the state of Palestine's government. And so by conditioning this recognition to the current Hamas-Israel situation, Great Britain is actually doing something wrong. Not contrary to international law, but like it is creating this appearance that there is a direct correlation between the recognition of Palestine and the October 7th and the reaction to October 7th military operation, genocide in Gaza. There isn't. Palestine should be recognized by other states because it is the right thing to do. Because Palestinians have a right to self-determination, and because they are being subjugated, occupied, genocided, apartheid, annexed, and oppressed, tortured, killed, and subjected to conditions of life calculated to bring about the destruction, and starved by Israel. And so, in recognition of their inherent right to self-determination, states should recognize Palestinian statehood. It has nothing to do with October 7th. It has nothing to do with Hamas. So, in pulling this situation of recognition of Palestine, forcing it into a Gaza gaze, into a Gaza scenario, it is sort of feeding the Zionist talking point that this is a reward for Hamas. So even in that, I'm sure that what Lamy tried to do was to say, oh, let's not just recognize Palestine, we need to do something else so that we are not like seen as too pro-Palestine. So let's add some conditions here and there to make this about humanitarianism and not about pro-Palestinianness. But what they ended up doing is weakening the cause that they claimed that they were defending. They weakened the cause of Palestinian statehood because they gave a talking point to Zionists about this being a reward to Hamas, which it isn't and shouldn't be framed that way. So let me continue. Hold on. Whatever the political thinking behind it, ministers should have been advised that this approach turns the doctrine of recognition on its head without any legal basis. Recognition cannot and should not be a lever against the third state. Can anyone seriously contend that the concept of a statehood that is negatable by another state through certain steps is in accordance with the principles governing recognition and statehood? On this, fair point. The point being, if to the United Kingdom, Palestine is a state only if Israel does not commit to a ceasefire, then that is a weird statement. That would be a statement that the United Kingdom is subjecting its recognition to conditions, and that is generally against the spirit of recognition of statehood. But you know what it wouldn't mean? It wouldn't mean that the recognition would be unlawful. And that's the key point here. We are almost done with the article. It's a little bit further down. And so far, there has been no defense of the statement that Marco was criticizing, that recognition would be unlawful, contrary to international law. None of the sort has been defended here. And that recognition subject to another state's option to preclude and that recognition subject to another state's option to preclude it is how we had hitherto understood recognition might operate in a legal sense. The French and the Canadian statements do not contain any conditionality directed at Israel. This is true. I remain deeply skeptical that the lex ferenda, so the law as it should be, idea of recognizing states notwithstanding the facts. It is an example of counterproductive conceptual acrobatics, which extreme cases sometimes encourage. I guess he's against the Vatican City existing. No one makes that case against the Vatican, right? The Israeli-Palestinian conflict has already spawned over conceptual absurdities, such as the concept of the occupying power that may not enter that which it occupies. We may now have a state either without a government or at best with a government, the PA, that is legally precluded from doing and factually clearly unable to do what it must do for that state to come into existence. I mean, like a lot of states during decolonization. The new state would also have a permanent population that includes people who will be understood to exist simultaneously outside the borders of the state, refugees, and within the borders of the state, nationals of the state of Palestine. None of this helps. Hard cases make bad law, and bad law makes hard cases even harder. But he's not defending that it is contrary to international law. One can express support for the plight of the Palestinians and strong criticism of the Israeli government's conduct while staying entirely within the framework of international law. Recognition of Palestine is within the framework of international law. That's the thing. You know how, he has not proven his claim. He has claimed a lot of arguments about how conditionality in recognition is off. And he has described what the law, what Crawford believed about the law in ways that are in agreement with Marco's article, and then concludes that, this would go contrary to the framework of international law. There is no need, he says, to distort established legal principles or resort to incoherence. At some point, hopefully sooner rather than later, this conflict will find a political solution, and if there is one reason for hope, it comes from the constitutive attitude and sense of purpose shown by some countries in the region, like the UAE, which recognizes Palestine, Jordan, which recognizes Palestine, Egypt, which recognizes Palestine, and Saudi Arabia, which recognizes Palestine, that called on Hamas to disarm and relinquish power. That political solution will need to take a lasting and coherent legal form. I am confused by the fact that the article just never defended the letter. The claim that recognizing Palestine will be contrary to international law is not made here. The claim that is made here is that conditionality is wrong, and that he doesn't agree with recognition notwithstanding the facts, but by quoting James Crawford in ways that Marco, I guess, would agree with. So again, there's no argument that there would be a rule of international law that is violated by not recognizing the Palestinian state. At best, there's an argument that he believes that Palestine does not fulfill the 4 requirements of the Montevideo Convention, and so recognizing Palestine, despite the fact that those elements are not present, would create practical problems. Okay, but that was not the claim of the letter. And again, all of these practical problems are either produced by Israel or easily solvable with the same way that 148 states have already done so. So yeah, I think the situation that has been created by these like announcements of recognition of Palestine is one where um, there's a bit of I don't it's not exactly desperation, sense of urgency on those who do not support Palestinian statehood, in fearing that the dynamics of the conflict will change, and that they will change in ways that will irrevocably be negative for Israel. Like the way the conflict has been defined for a very long time now is that statehood is the star in the forehead for the good Palestinian that does not protest too much. And if you swallow enough of your pride, if you accept enough of a Bantustan as a state, we will give you a little star in your forehead and call you a state. And what most of the global south has said for a very long time now is no, no, no. You want a two-state solution, you need two states. There's no such thing as a two-state solution negotiated by a state and a non-state actor. So if that logic enters the West, the core, the imperial core of the West, France, Great Britain, Canada, then that will be irreversible. There's a reason why Kosovo is perceived more as a state than Palestine, even though more states recognize Palestine than Kosovo. Because the states that recognize Kosovo are the imperial core, are NATO states. That's it. So there is a sense of urgency in that the dynamics of the conflict are changing rapidly in ways that no longer reflect that this narrative of but the conflict is so complicated. Like if you solve Middle East peace, then oh my god, you deserve the Nobel Peace Prize because it's so complicated. And then all of a sudden, the global South narrative of like actually it's not complicated at all. Colonialism is very simple. Is starting to creep into discourse, and people are starting to get fed up with their governments not doing anything about Palestine. And yes, recognizing a Palestinian state will not solve the situation on the ground, will not end the genocide. It will frankly change very little in the dynamic between Israel and Palestine. But incremental change is scary to someone like Israel, that requires oppression to be the norm. They cannot afford incremental change, no matter how small. And so even though facts on the ground would be not very much affected by this, it is still a massive tectonic shift. It will affect the way international relations are played out. Inevitably, right? If the UK and France have recognized the Palestinian state, they will need to treat it as a state. And that is something that I think Israel did not expect. I don't think if you had told me like 3 years ago, you know what, in 3 years, France, Canada, the United Kingdom are going to recognize the state of Palestine with whatever conditions you want to tell me, demilitarized state and all of that, I would have told you, no way, that's never going to happen. And now it's happening. So I'll take that. I'll take that incremental change. It'll be good. Because little by little, you start winning these little battles, and eventually they add up, right? So yeah, I think it's positive. Doesn't matter if it's done. Like the reason why these states are doing this is not because they all of a sudden care about Palestinian life. They don't. Macron, Starmer, they don't care about Palestinians dying. What they care about is two things. Number one, they care about their constituencies. You don't have to be a genius to read polling and know that whoever is against Palestine faces an uphill battle with the electorate. Kamala Harris lost the election in no small part because of his lack of support for Palestinian self-determination and rights. And so they need to do something about that. Now, they cannot really do something that stops the gen. They cannot just, like, I don't know, approve a Security Council resolution to, like, enter Gaza and stop the genocide. They cannot, I don't know, impose sanctions on the Israeli economy. They can't do that. They need something to please their domestic audiences, and recognition of Palestine seems, harmless enough. It won't be enough. People will still be in the streets. And so some other carrot will need to be thrown to the electorate. But you will have already won recognition of the state of Palestine. And the other reason why they're doing this, I think, is because they're really pissed off at Trump. They're really pissed off at like, I think Starmer and Macron, and like, I think they are, um, they don't really want it. They didn't really want to recognize Palestine, but they sort of feel that it is the only way in which they can signal to the United States, if you keep pushing, there are things that we can do that you won't like, which is what Lula did to the United States in 2011, right, by recognizing Palestine as well. It is a very simple way of telling the United States, we are no longer as aligned with you as you want us to. It's it's a very, very common tactic, recognizing Palestine as a way of signaling opposition to the United States policy. So Starmer was all about, like, oh, no, 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 I won't do this, I won't do this. And then all of a sudden, because France does it, because Canada does it does it as well. That was staged. It was planned. They all got together and said, okay, we're going to do it together so that it doesn't look that bad. We'll throw a bone to our electorates and we'll piss off Trump, and we will start this campaign to make Europe more independent from the United States. Win-win. I win at home, I win abroad. That's what's going on. Like, let's not be naive here. They don't care about, they do not care about Palestinian lives. But I'll take it. I'll take any incremental win that I can get. And if it makes, let's put it this way: if it makes people that do not believe in Palestinian rights, I'm not suggesting that this is Lord Verderame or anything like that. Like, in the abstract, if it makes people, if it makes internet trolls that hate Palestinians lose their minds, then I'll take that. It's small, it won't end the genocide, but it'll add up. I remember when I was in college, in law school, and Palestine filed an application for membership in the United Nations. At the time I wrote an article, it's in Spanish somewhere on Spanish-speaking internet, there's an article by me on this, and I said, this is momentous. Something like that. And yet it won't work. Palestine won't be accepted as a state into the United Nations, but it might get observer status. And there's a lot that Palestine can do with observer status. It's now 15 years later, 16 years later. There was a lot that Palestine did with that observer status. It joined the ICC, thus enabling this case in Gaza to be moving forward. It went to the ICJ, filed like 3 different advisory opinions. It gained a voice in the General Assembly. There's a lot that Palestine could do with a relatively harmless status of observer state. Same with this. Being recognized as a state by Great Britain, France, and Canada, there's a lot that you can do with that diplomatically. And I guess in this, like, good cop, bad cop game of, like, who is the side that is acceptable to the international community. The state of Palestine right now is sticking, remarkably sticking to its diplomatic alternatives, to its diplomatic channels. To my frustration, I think they should invoke collective self-defense by now. But they are sticking to this, like, diplomatic avenue, and it seems to be rendering fruits, right? Again, it won't stop the genocide, but I think the plan that they have is in decades, right? And so we need to be mindful of this double situation. that we need stuff that works now. End the genocide. Stop sending weapons to Israel. Stop collaborating with apartheid. Stop collaborating with the settlements. Stop collaborating with the Israeli economy. Sanctions, all of that. That is in the now, immediate. But then there's also the long game. And in that long game, this recognition, no matter how flawed, I'll take it. I'll take it. So South African Jartov says South African humanitarian intervention invasion. No, I think it's more subtle than that. I don't expect states to just launch a coalition of the willing like that. Um, but I mean, I do think there's a lot of things you can do again with Palestine saying collective self-defense, um, including, like, for example, including um, shooting down drones and like missiles and stuff like that. The same way that um, in the same way that Jordan does it for Israel whenever Israel attacks, you know. Um, and then let me see who else says. Convexity hedging says pariah states become so slowly and then suddenly. Yeah, absolutely. I think I've said this before. I think Israel will never recover from this, and they know it. That's why they are so desperate. That's why they want to achieve all their goals. That's why they want to empty Gaza of Palestinians, because they know that it's now or never. If they don't do it now under Trump, they will never again be able to do it because they will be a pariah state forever. It'll take decades, it'll take generations for Israel to recover the same kind of immunity and impunity that it enjoyed between 1948 and 2022, 2023. It will be generations before they go back to normal, like to quote unquote normal. Okay, guys, it is 7 p.m., which means that I have to go cook dinner. So I'm gonna stop the stream here and go make dinner.